Hello, ladies and gentlemen. Welcome back to Power Vacuum. I'm your host, Belmont. I'm coming at you today with more legal drama coming out of Nintendo. This is about an old the lawsuit's new, I should say, but it's about an old issue they've been having with the modding community. And man, I don't know if this guy's brave or just stupid, maybe a combination of both, but let's find out. Modded hardware. Defendant denies Nintendo copyright claims in court. And when they say denies, this guy thinks he can just get away with writing the word denied on a legal document, but we'll get to that. This is from Torrent Freak, who reported on this. The alleged operator of modded hardware has filed an answer to Nintendo's copyright claims, denying any wrongdoing. The defendant, who represents himself in court, counters with a long list of affirmative defenses, including fair use. The case will now move forward to the discovery process. Meanwhile, the modded hardware site has gone private. Typically, if you have to make your site private in the middle of a lawsuit, you're not on the winning side, or you know that you're doing something wrong and you're trying to hide it. His defense of fair use is interesting. Let's see if the article addresses it before I talk about that. Nintendo is doing everything in its power to stop the public from playing pirated games on the Switch console. That seems fair. The Japanese gaming company has won several lawsuits in recent history, including shutting down websites that distributed pirated ROMs. Most notably, perhaps, was the criminal referral that resulted in the demise of the infamous hacking group Team Executor. The group had previously released several jailbreak hacks for gaming consoles and widely regarded as Nintendo's main nemesis. Really? Were they? I mean, I'd heard about that, but I didn't think they were a nemesis. With the win against the Team Executor, Nintendo hoped the modding scene would fade into oblivion. But that's not what happened. No, of course that's not what happened, Nintendo. You can't stop modding. Especially physical modding, because a dude can go to somebody's garage with his Switch in person and you won't even ever hear about it or know about it. This guy was running a website, though. In fact, this is hilarious. What is it? Modded hardware? No, I don't want that. moddedhardware.com. Look at this. Bam! Password locked. You want to get in? You got to know the password, which means you probably have to already have been a customer, which means you probably don't have a need for the website anymore, right? I don't know. Let's see. Where was I? What happened? For example, recently Nintendo went after various Switch piracy-related tools, including the Yuzu emulator, Lockpick, and MIG SWITCH. Ooh, yeah, MIG SWITCH. Those guys, I have only recently heard about MIG SWITCH, but when I heard what they were doing, I was like, man, these guys are gonna get popped. In June of this year. Oh, now Nintendo vs. Modded. Nintendo filed additional lawsuits in U.S. courts to further intensify the crackdown. One of these complaints targets modded hardware and its alleged operator, Michigan resident Ryan Daly, who's also known under the alias Homebrew Homie. That's interesting. Not a bad handle. Nintendo and Daly were no strangers at the time. In March, Nintendo threatened Daly with a lawsuit. Both parties agreed that the alleged unlawful activity, which includes selling MIG devices, pop it up again, and modded consoles, would stop. That didn't happen, however, so Nintendo sued Daly at a federal court in Seattle instead. Mod chips, MIG SWITCH, and pirated games. In the complaint, Nintendo alleged that modded hardware sells several pieces of hardware that circumvent its piracy protections. These include mod chips and the MIG SWITCH, a memory card that allows people to play pirated copies of Nintendo Switch games on authentic consoles. Nintendo Switch options. I think these shots are from his original site before it went private. Mail-in mod chip install service for all model Switches. And then modded Nintendo Switch OLED Lite and regular models. See, now these are the kind of mods that you can get away with. Damn, Navi, what the fuck. These are the kind of mods you can get away with, like OLEDs, light up buttons, uh, putting in different backlighting. Nintendo's not going to come at you for that. It's physically modding the console isn't really an issue that they have. But when you're trying to circumvent like hardware restrictions, that's different. And then plus, by the way, if you're physically modding a Nintendo Switch, all props to you. I don't know if you've ever opened up a Nintendo Switch, but that is a reassembly nightmare. Like the people who have to repair Nintendo Switches and do like minor circuitry repair, bravo, good sirs and madams, because that is not something I would want to do. Opening one of those things up, it's like when you take something out of a box that's really packed in there, you can never quite get it right back in there the way it was before. That's what opening a Nintendo Switch is like when you like actually crack open the console. You feel like you're not going to be able to get all the shit that's in there back in because it is so packed tight in there. Like, I'm surprised these things don't have overheating problems. But I guess that's why Nintendo stays on cartridges and not disc-based systems. In addition to selling hardware hacks, the defendant also offered mail-in modding services and modded versions of Switch consoles for the less technically inclined. These were reportedly loaded with pirated games, according to the complaint. Defendant not only offers the hardware and firmware to create and play pirate games, but he also provides his customers with copies of pirated games, the Nintendo games. The complaint reads. I'm jumping around too quickly. Typically, with a customer's purchase, see? There you go. Screwed up. Typically, when a customer purchases a hacked console or the circumvention services devices, defendant pre-installs on the console a portfolio of ready-to-play pirated games, including some of Nintendo's most popular titles, such as Super Mario, The Legend of Zelda, and Metroid games. Ooh, there's your mistake. You never go for the big one, well, two of the big three. Metroid's kind of fallen by the wayside a little bit, but Nintendo's big three are Mario, Zelda, Pokemon, and they will get you for that shit. Overall, Nintendo alleges the modded hardware trafficked in circumvention devices by selling mod chips and MIG devices that violated the DMCA, for which Nintendo demands damages. In addition, the gaming company seeks damages for direct and contributory copyright infringement, accusing the defendant of adding pirated games to consoles. See, now here's the issue, is if they really believed he was doing this, they very well could have had one of their lawyers place an order for this guy and get a console, and if they didn't request him to add games and he added him, he's cooked. He's not just cooked, man. He is pan-seared on both sides and finished off in the oven. Like, I don't know how well Nintendo does their research, but I feel like they've got some of the best lawyers in the world. He modded hardware, denies any wrongdoing. This week, Ryan Daly filed an answer to the complaint. The alleged modded hardware operator goes up against Nintendo without an attorney and denies any wrongdoing. This includes the claim that Daly owns and operates the modded hardware business. Is the owner, maybe? All right. Yeah, look at this. Here's the complaint. Number 28, line 9. Defendant is the owner and operator of a for-profit online business known as Modded Hardware, located at moddedhardware.com, the website. Via the website, defendant offers a variety of products and services designed to circumvent and bypass Nintendo's TPMs. Answer: denied. Like, this just seems like a guy that went online and went to like Reddit and 4chan and asked for a bunch of legal advice and shooting himself in the foot. The answer doesn't include much substance. It mostly repeats Nintendo's claims, simply responding with the word denied. In response to more general allegations, Daly replies that he lacks sufficient information to either admit or deny the allegations, which are therefore denied as well. The harm to Nintendo's from defendant sales and distribution of the circumvention devices, hacked consoles, and invention services is substantial and irreparable. Nintendo's business relies. Well, I'm not going to read all this. Answer: defendant is without sufficient information to either admit or deny the allegations of this paragraph, and on that basis denies them. Yeah, so he probably read all that and was like, yo, this is in like lawyer speak, and I don't know lawyer speak, and I'm not hiring a lawyer to explain it, so I'm just going to say I don't understand. The problem with that is judges love to say the phrase, ignorance of the law is not absolution of the law. Which basically means just because you don't know you're doing something wrong doesn't mean you can't get in trouble. These types of responses are not uncommon in answers to a complaint. What is unusual, however, is the defendant is not represented by a lawyer. Without making any inferences about the validity of Nintendo's claims, it's generally not easy for a pro se defendant to counter a seasoned team of Nintendo lawyers. Yeah, the real problem is he's probably gone to lawyers and been like, Nintendo's suing me for these reasons, and they're probably like, yeah, you're fucked. Like, this is oh, did you actually agree to stop doing this and you didn't? Yeah, that's a binding contract. Like, you don't have to sign a piece of paper for it to be a binding contract. Like, are all agreements binding contracts? No, of course not. Agreements made under duress, not a binding contract. Agreements that have no penalty of further legal action, not a binding contract. But if you make an agreement with a person or a company to stop doing something under threat of legal action because you and the company both agree that what you are doing isn't in the realm of legality, you have now committed a verbal contract, which is still binding, especially in the court of law, or in this case, it's probably a written contract, unsigned written contract, because like, if you get sent an email that's like, hey, you're infringing upon copyright, you need to stop, and you go, okay, I will, and then you don't, you agree to a contract, whether you know it or not. That's where the legal system is crazy. Now, will you be able to claim duress? Maybe. I don't know, but I doubt it. Fair use and other defenses. Now, this is the part I wanted to get to. In addition to the denials, Daly presents a list of 17 affirmative defenses. Oh, I did not need that definition. Oh, shit. Goobered. I just goobered that up. I'm going to have to cut this out. I apologize, everyone. Or I could just let you watch me do this. Whatever. I'm not cutting it out. I'm going to leave in my sloppy mistake. These include fair use, invalid copyrights, a lack of standing, fraudulent inducement, an arbitration clause, failure to state a claim, and unjust enrichment. The answer doesn't elaborate any of these defenses. Okay, so arbitration clause. I'm going to answer this one real quick because a lot of people seem to think that when you agree to an arbitration, that you have to go through arbitration before you go to any court dealings. Every time you sign an arbitration clause, not an arbitration. That word doesn't mean anything. Arbitration clauses always have, usually is like the last line or a couple lines near the bottom of the clause, a statement that is infringement upon monetary value. Right? Now, it's not exactly worded like that, but basically arbitration clauses say if there is an illegal act committed that involves a monetization of any kind, you gaining money, you taking money from them, this usually allows them to circumvent arbitration. Now, if Nintendo's suing you right off rip, their lawyers have already said that you've probably committed the thing that allows you to circumvent arbitration. Infringing upon copyright circumvents arbitration. Okay? I don't think trademark does. I think you have to do trademark battles in arbitration, and if arbitration cannot reach a closure, then it goes to court. But it's been a while since I've studied business law, so don't quote me on that. But yeah, third affirmative, yeah, are barred by the doctrine of fair use. Now that Daisley has answered the complaint, the law can move forward to the discovery process. At this stage, both parties can gather evidence, which typically includes deposition, interrogations, and requests for documentation or documents. I'm lawyering that up. Whether they like to monitor. Yeah, okay. All right, I'm going to address this fair use thing. This guy doesn't know what fair use is. Modding hardware is not fair use. Fair use, it protects a very limited scope of things. It takes a lot of work to even get parity protected by fair use. How parity is protected by fair use, when like people make jokes and stuff, is that parity is a form of commentary. And that's one of the things. So fair use protects commentary, educational purposes, and review purposes. Mostly because review involves commentary. But the two big things that you can use fair use for, education and commentary. Right? That's what fair use is. I can upload videos of me showing gameplay of Legend of Zelda because I am commentating on the gameplay, right? Or I'm providing an opinion. I can upload tutorials because they're educational. How to use the hook shot, things like that. That's what fair use is for. And parity is often one of those things that borders being on lawsuits constantly, because some people go, hey, you're stealing my content. Other people are going, oh, it's a parody, which is basically my commentary on it done in a different manner. I do not see how circumventing software or hardware and allowing people to illegally play games is fair use in any way. I don't think this guy knows what fair use is. The fact that he's representing himself once again makes me feel like he's gone to lawyers and they're like, no way are we touching this case. You guilty as hell, son. Just give up now. You shouldn't have told them you were going to stop when you didn't. I'm just imagining how these scenarios went, because like, you don't represent yourself against a major company unless you have like rock solid proof that you haven't done anything wrong, or that your claims are correct and theirs aren't. But well, let's see what his defenses are. Fair use, applicable statutes of limitations. I don't know what he's seen. See, I wish I could get these actual court documents, but most of these on a PDF right here. Well, thank you, torrent freak. See, this is why I like some websites more than others, because they actually give you the stuff you're looking for. Here we go. This is the legal mumbo jumbo, and I don't expect anybody to stick around. The defendant is without sufficient information. Defendant is without sufficient information to either admit or deny allegations. Okay, so he's used that defense twice, huh? Yeah, so I'm not going to bore you guys with this. I might do a follow-up video. No, that's a lie. I'm not going to do a follow-up video. I am going to read through this, though, because this is interesting. That I tried looking for this like on my own earlier and couldn't find it. And I should have just scrolled to the bottom of this damn article. Yeah, nothing in here would be protected by fair use. Statute of limitations is a weird defense, considering that statute of limitations typically applies to crimes, and it actually applies to the date of the discovery of the crime, not the committing of the crime. That's a huge mistake that like Hollywood and TV has misconstrued with people. They think that, okay, so let's say you and your friends rob safety deposit boxes in a bank. You somehow shut the system down. You get in. You get a bunch of money from safety deposit boxes. You get out. And nobody notices because the boxes you robbed, nobody ever checks. But then 10 years later, somebody's like, oh man, I got robbed. I just checked these boxes and they're empty. And then you're like, ha 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 ha, yeah, that was me and my friends, but we did it 10 years ago. You can't do anything about it. Well, no, they just discovered the crime and you just admitted it. And bam, the statute of limitations start upon the discovery of the crime, not when you originally committed it. So like, it's one of those weird things, like certain crimes they know right away. Murder. Oh, we found someone was murdered. That's why there is no statute of limitation on murder. But yeah, I don't know what his defense is going to be for that. Fifth defense is bar due to lashes, bar due to unclean hands. I don't even know what he means by these things. These are like, this is the thing where like, again, he's looking up legal defenses online, talking to people on Reddit, talking to people on 4chan or whatever sites people use now, and he's just being fed information that he doesn't fully understand, and he's just throwing this is the spaghetti defense. Throw it all at the wall, see what sticks. And yeah, without like a handful of lawyers to back you up, you're not going to win. The spaghetti defense hardly ever works. That's why nobody uses it. I mean, the people that do use it, they usually use it not as a defense. It's more like prosecution does this, a spaghetti technique. Throw everything at them, and one of those charges is going to stick. But I can't wait to see where this goes, because I think this guy's, I think he's fried. Like I said, he's getting pan seared on both sides and finished off in the oven like a fine steak made by Gordon Ramsay. But that's all I have for this video. Belmont out.